All right, and we're here for sentencing on charge of malicious destruction of personal property over $1,000. It's punishable by a maximum of 5 years in prison. The guidelines have been initially scored at 0 to 6 months. Mr. Gilbert, have you had a chance to review that report and recommendation with your client?
Yes, we've reviewed the report and the recommendation with my client. We have no additions or corrections, and we have no challenges to scoring.
Mr. Juliet, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Mr. Gilbert, anything you'd like to say on the client's behalf?
Yes, I would point out that Mr. Hefner would like me to, that he has been addressing. I believe there was some, it's reflected that there's pending charges or issues with Mount Pleasant and Saginaw. He has been in contact. I believe Mount Pleasant was resolved and Saginaw is in the process of being resolved. They know where he's at and he's been addressing those items. In addition to that, Your Honor, we asked if the court follow the recommendation. I believe Camden has learned his lesson from this. As the court knows, he does have another pending case, but I think this time in jail has been a very big eye opener. Prior to this, and I know he's conveyed this to me on many occasions, prior to this, he never really had a jail experience. And he's a young man, and this is the first one he's really had. And I think it was an eye opener. He's in there with people that he doesn't necessarily want to be around or be like. There was one instance where, in another case, and I know the court saw the video. When I saw the video, I was very proud of Camden. There was a fight in the cell. What does Camden do? He hightailed it as fast as he could away from that, so he wasn't involved. And there's me watching it as I saw what was happening. I was very proud of what Camden did. That Camden that I knew years ago in the juvenile court probably would have been involved with that. And so I think this has been an eye opener. And he does understand that he has to get his temper under control. He does have a temper issue, but again, the jail has been a very big learning experience. Thank you.
Thank you, Mr. Hefner. You don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
No.
Mr. Juliet, any recommendations from the people?
I would ask the court to follow the recommendation for the probation and credit for time served in this case.
This sentencing starts calm, but the weight is already heavy. 5 years maximum hangs in the air like a warning sign. 0 to 6 months sounds light until the history walks in the defense, tries to clean the record with polite courtroom language. No challenges, no corrections, everything looks neat on paper. But jail time already changed the tone of this young man. First time locked up hits different than warnings on probation. The lawyer paints growth lessons and maturity. Avoiding a jail fight becomes proof of character. Temper issues admitted like a controlled fire. The court hears hope mixed with damage control. This is the calm before the storm. Everyone knows the judge has not spoken yet. The room is waiting for the real evaluation. Polite words cannot erase violent moments. The sentencing chessboard is being set.
The defendant's 19 years old and he's already got his first felony. He has significant juvenile history. I remember because I was the prosecutor in most of those cases. Now he's got more pending felonies, so I certainly hope this was an eye opener. I'm not going to rehash the facts that the court set for this trial, so I ask for all the recommendations.
All right, well, this is a really hard one, Mr. Hefner. We did have a trial in this case, and this was a very serious offense. When I think about what's an appropriate sentence within a guidelines range, we've actually had some cases today where we think about, well, gee, other conduct that would have been worse would have still been in the same guideline range. And here, other conduct that would have been far less serious would still be in the same guideline range. If you had keyed Mr. Hush's car, you'd be here convicted of the same offense with the same guidelines range. But this was a pretty frightening situation. You were at a outdoor party gathering that had a bunch of young people there, and some of them fueled by alcohol, I'm sure. And then you gather up a crowd of people to go get someone as they're trying to leave in their car. and their car is surrounded while you and others that you have riled up are pounding on it, kicking it, trying to pull them out. And what were you going to do if you got them out? Beat them up. And there's a girl with them in the car. What's going to happen to her? That's a very serious malicious destruction of property case.
The defendant stays quiet, which sometimes speaks louder. The prosecutor remembers everything from years ago, juvenile court memories, do not fade for the bench. First felony at 19 is not a small footnote. Hope is mentioned, but doubt is louder. The judge signals this will not be routine. Guidelines feel narrow for behavior. This chaotic, the tone shifts from paperwork to reality. Trials change how judges feel about conduct. This is not just numbers on a chart. This is about fear and danger. The court prepares to describe what really happened. This is where sympathy starts losing ground. Youth is noted, but not excused. The judge is loading the facts carefully. Everyone senses consequences coming.
For anybody inside that car, that'd be a terrifying situation. It's not just you on the outside, it's the other folks that you've rounded up. And then I look at, okay, that's the seriousness of the offense. What about the seriousness of the offender? I know this is your first felony conviction, but you've been busy. In the juvenile court, you had a 2021 MDOP misdemeanor dismissed after a delay. So you're put on probation for destroying somebody's property or damaging somebody's property 4 years ago. Then the next year, receiving, concealing stolen property and a home invasion. And then the next year, 2023, guess what? Another malicious destruction of property misdemeanor. Then you get discharged from juvenile probation in April of 2024. Within 4 months, you commit this malicious destruction of property, a felony, that I consider a very serious event. Then while the case is pending, in October of 2024, you get an assault and battery charge out of Saginaw, for which you're ultimately convicted and get probation. Then, in August of 2025, you get a felony resisting obstructing police charge in Isabella County that's scheduled for court next week. And then in September of 2025, back in this county, you're charged with discharging a firearm from a moving motor vehicle, and you're set to be arraigned by me next week. My goodness, I mean, Mr. Hefner, that's a young man that is just out of control, and being on juvenile probation didn't slow you down. Being on felony bond didn't slow you down. So what's it going to take to slow you down? So your lawyer's telling me you sitting 83 days in jail has changed your life, and now you're going to stop doing this stuff. Why should I believe that to be true? Is there anything you got for me today? Like, what have you learned?
That jail isn't somewhere that I would like to be. I need to be there for my son, and that I need to do better in life. And I see that I don't want to be like these people in jail going to prison. I don't want to be. I want to change. I want to do better. I know I have a drinking problem. I need to get like some sort of rehab, some sort of something. I know that. And I reached out to an outpatient, and I was accepted to one.
This is where the courtroom goes cold. The judge paints the scene in brutal clarity. Crowds, alcohol, anger, and motion collide. A car becomes a cage instead of transportation. Surrounded fists, hitting glass. Fear inside. What happens if the door opens is the real question. Violence was seconds away from exploding. A girl trapped inside raises the stakes instantly. This was not property damage alone. This was terror disguised as vandalism. The judge makes sure everyone understands that fear is part of the sentence calculation. The courtroom feels the seriousness shift. This is no key scratch on paint. This is mob behavior in motion. The weight of the crime settles hard.
Just depending on what happens here today.
All right. So I honestly don't know what to do, Mr. Hefner. I mean, well, we've got a couple pending contempts for the pending charges. I mean, I'll dismiss both of those pending contempts We're here for sentencing on this one. The other cases are still pending, so it doesn't make any sense to proceed with those contempts. But then, you know, I'm really torn here with what to do because, you know, I want to make sure that what I'm doing when I'm here on this bench is keeping the folks in town safe. I also am looking at a young man who's 19 years of age. I don't want Mr. Hepner to draw a lesson at 19 that the system only exists to come down on him like a load of bricks. You know, I do want to hold out hope, given his youth, that probation can help. But, you know, that's only going to be if you participate. You know, probation isn't going to make you any better unless you participate in what's going on. So I don't know. I mean, I think I have to kind of combine some things here. So I think taking all these things into account, what I'm going to do, Mr. Hepner, is place you on probation for 2 years as recommended. That's subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report. I want to highlight some of those conditions for you. You have to complete a substance abuse assessment when you're referred by your field agent, and outpatient or residential substance abuse treatment when you're referred. You have to participate in adult education or GED. So we want you to finish your education. We want you to get sober, stay sober, get treatment for that. No contact at all with Mr. Hush. We want you to get a job, full-time employment, and keep a job.
History crashes into the present. Like a wave, probation did not slow down juvenile cases, stacked one after another dismissals, delays, chances given, and wasted felony bond did not stop new charges. The timeline reads like acceleration, not reform. Every chance became another incident. The judge is no longer asking softly. The question is, why now should things change? Jail is not supposed to be the teacher, but suddenly it becomes the excuse. Fatherhood enters the courtroom conversation. Rehab is mentioned as a lifeline. Words sound sincere, but timing matters. The judge listens without interrupting. Trust is the real issue now.
There's a restitution, but that was paid by the co-defendant, so I don't think we can double dip on that, and it'll be up to the co-defendant to sue him for contribution, I think.
I agree.
Okay, so I'm not going to assess any restitution, so that's at zero. It's been paid by the co-defendant. There's a crime victims assessment of $130, court costs of $350, state cost is $68. You have to comply with DNA testing and pay a $60 fee, and there's a monthly supervision fee to the Department of Corrections. I'm going to, Agent Martin, I'm going to add a couple terms of probation. Because Mr. Hepner's been cruising around without much regard for the community, I wanted to do 100 hours of community service. And I want him to have a curfew. And and at did I say 0 to 9? It was 0 to 6 months. Okay. You know, Mr. Hepner, you are on a fast path to significant incarceration, including prison. So I do think, given the seriousness of this situation and the pattern of behavior that brought you here, I'm going to order that you serve 5 months in the Sheboygan County Jail with credit for 83 days previously served. And it's within the advisory guidelines. I think it is, there's reasonable grounds for incarceration despite the intermediate sanction because of his pattern of behavior up to this case and the pattern of continuing criminal behavior while he was in bond in this case. And Mr. Hepner, you are entitled to appellate review of this conviction and sentence as a matter of right. If you are unable to afford a lawyer, I would appoint one to represent you on appeal. But you must file the request within 42 days after entry of the judgment of sentence if you want to appeal by right. We're going to hand you a piece of paper explaining that, ask you to initial one copy, the other one's for you to fill out if you want to appeal. And also, you're eligible for early discharge from probation at the halfway point. If you've successfully completed all its terms, we're going to hand you a piece of paper explaining that process. Within 24 hours of your release, I want you contacting your supervising agent. Okay? And if you violate probation, you can expect a lot more time from me. All right, good luck, Mr. Hefner.
I think the judge made the right call. Tough but fair. What do you think? Tell us in the comments. And don't forget to subscribe for more crazy courtroom moments.
The judge wrestles openly with the decision public safety sits on one shoulder, youth and potential sit on the other. Probation is framed as opportunity, not mercy. Rules stack up fast and deliberately. Treatment, education, work structure, discipline, community service, curfew, accountability. But jail time still comes down hard. 5 months sends a clear message. Patterns matter more than promises. Guidelines support the sentence, but behavior seals it. Appeal rights are explained like a final formality. Early discharge is offered as motivation. The warning about prison is unmistakable. This is tough but intentional justice. Now the audience gets to decide.